versus Hebert. Mr. Schmidt? For real? Did he check in, Banc Courtroom? Okay, I wonder if he's in the wrong courtroom. Oh, that's a first.
Yeah, me
At least for me.
too. Me too. You haven't seen him, you know him and you haven't seen him at all today? Oh, there he is.
Okay, the case we're calling is 21-30658, Randall Kling versus Troy Hebert et al.
Oh, looks like we got the one. They're calling to me.
But you're here on behalf of Mr. Kling? Okay. Well, I thought I called for the right case and the right people, so assuming we have who we need here, so, okay. I mean, the sign-in sheet was showing Robert Schmidt for Randall Kling, and that's what, so, okay. All right, well, good then.
Who is he?
Huh?
Who is he?
He's
Is he Robert Schmidt?
right.
You're up?
Good morning. May it please the court, Rob Schmidt on behalf of Randall Kling. I do not believe I'm going to require my whole 15 minutes, or I think the issues have been pretty thoroughly briefed by the parties, and there are only a couple of points that I would like to hit. You know, the first main issue is this jurisdictional issue. Of course, we recognize that a factual attack on jurisdiction can be decided based on the evidence, and that when there is a factual attack, the party asserting jurisdiction has to come forward with evidence showing that the court has jurisdiction. The problem is that the defendant's argument here that Mr. Kling's claims are not plausible is not a factual attack on jurisdiction. That's a merits question. The law of this circuit is clear that the court has jurisdiction over a reinstatement claim under Section 1983. That should be the end of the analysis, but the defendant's position is that his claim for reinstatement is not plausible, and the court does not.
But I think what they're saying, what the district court found, is that all the exhibits that you accept could be looked at, conclusively determined, indisputably, that he doesn't live in the state. He's lived outside long enough that any appropriate certification has lapsed, and maybe most importantly, it would be impossible to reinstate him because the position's gone. All of which are true.
All of which are merits questions. All of which are questions.
But is there a dispute of fact as to them? If not, the district court said, I don't have the equitable authority to give you the only thing you're asking for, reinstatement. I lack the power to give you the only relief you're asking for. So then you tell me where in the record, all these exhibits, there's an issue of fact as to that.
There's not an issue of fact as to any of those things in the record, Your Honor. We're not claiming that there is. Our argument is that those are not things that concern the court's authority. They concern who is right.
But having the injunctive power to give relief, if it's not disputed, that the court couldn't give the relief you want? How does the court have jurisdiction?
What I am hearing Your Honor saying is that the correct action for the court in that case would be to deny it, to find, okay, reinstatement is not appropriate. That by making that ruling, the court is assuming that authority and exercising that authority. By determining factual questions such as, is reinstatement possible? Can he be reinstated? Is he certified? Is he qualified? All those things, those are questions that the court has to have jurisdiction to be able to decide.
So what's your I usually fall back on this. What's your best case that in the face of undisputed exhibit evidence, that the position that, one, the only thing he seeks is prospective injunctive relief against Lombard for reinstatement, given that, if the position is one that can't be given to him, how does the court have jurisdiction? How does it have the power to give relief that you acknowledge there's no dispute he can't be given?
I do not have a case on that specific of a point.
But that's how the district court ruled here, correct?
It is, correct.
So what's your best case that that's reversible error? What's your best case?
Say the Supreme Court's holding in the Lexmark case that the plausibility of a claim is not a jurisdictional issue.
But it's implausible. It's inconceivable. It's impossible. The position doesn't exist.
Those are questions either for a Rule 12b-6 motion or a motion for summary judgment. The problem here is that it was filed as a 12b-1 motion. We didn't have any opportunity to conduct discovery on those things. And so, I mean, what's the problem with this is if this rule is accepted, then a defendant in any case could file a motion arguing that the plaintiff's claims are not plausible, call it a 12b-1 motion, and attach evidence, and then the plaintiff suddenly has to defend this evidence-based motion on the merits without having any opportunity for discovery.
Well, there's considerable discovery. He was deposed, and he says, I'm in Texas now. I don't have the right degree. Disagree with me if I'm wrong, having read the record.
That was in the state case.
Right, but it's in this record. It's judicially noticeable or not?
It is. Yes, sir.
So, and what about the point that there's no position at all left? It doesn't exist. Is that all? That was in the state case too, presumably? They restructured?
I don't recall if that restructuring had been done during the state case or not. But we...
You don't
Sir?
You do or don't dispute the declaration that's in this case?
We don't have any basis to dispute it or not because we didn't have a chance to do discovery.
All right. Well, that's your position.
Well, you're the appellant that's here, so, I mean, I'm a little confused as to what you're urging, other than you want to get to merits, but the threshold motion was a 12b-1, and a 6, which puts into play whether the court could legally do anything in terms of what's asked. And so, as I understand it, your client doesn't dispute any of the matters, so I don't quite understand about the discovery bit of it. So
it's that we haven't had an opportunity to conduct discovery to determine whether there is evidence to dispute it.
But maybe I'm misunderstanding. The viability of reinstatement is a legal question, isn't it?
Well, in this, not necessarily. The plausibility in this case, I think that both parties' briefs demonstrate that it's very much a factual question. I mean, what the defense is saying about the restructuring that's been done, all this, those are all questions of fact.
Well, I'll just say we're not going to tell you how to make your argument. You've briefed it, and if you want to stand on, what you briefed, then so let it be. We'll hear from counsel argument, but if you're confident enough in your position that you want to stand on the brief, you certainly have a right to do that, and we'll shift to the other side and hear the whole argument. But if we decide something different from what you expect, you know, you can't say you didn't get a chance to convince us to the contrary. So that's all. The time is yours. If you feel like you've said it in the brief and you don't want to, you know, explore further, then that's fine. You know, we're good.
Can I speak briefly on the prescription issue?
Yeah, I mean, like I said, it's your time. You're the appellant. You asked for the appeal.
Yes, sir.
So you're here, but you are sort of presenting like, why am I here?
Yes, sir. The main point that I wanted to make on the prescription issue is that it is not disputed that the timeliness question is determined by Louisiana law, and that cannot be disputed. It is. Defendant's argument in this case is not based on Louisiana law on the prescription issue. The whole argument is based on federal district court decisions.
The consensus of every federal district court that I see that's looked at this.
It does appear to be.
So your argument would ask us to say every federal district court that's looked at this issue was wrong? Are we required to say that for you to prevail?
Yes, Your Honor.
Okay. And then we said it in an unpublished Joseph case too, correct? What is it, Joseph versus New Orleans, City of New Orleans? We said the same thing.
Yes, Your Honor.
Okay, so all of that federal law has just been wrong.
It's based on Louisiana law, Your Honor.
Well, they're not denying, no one's denying it's based on Louisiana tolling or interruption.
Right.
But those courts have said no tolling, no interruption. They're all wrong, including our court in that unpublished decision.
Right. Well, in all these cases that have been cited by the defense, you know, in addition to being federal district court decisions, which are not determinative of Louisiana law, they also were distinguishable. I mean, there were all cases in which the federal cause of action that was asserted was something different than the state cause of action that was asserted. They're not analogous to this case here, where it is the exact same claim.
So what's your best state case? Is it how do you pronounce French pronunciation, Louvière?
I believe it'd be Louvière, and then also the Ramey versus DeCare case, which says that the cause of action is defined as the operative facts that give rise to a claim.
The Ramey?
Yes, Your Honor.
That dealt with peremptory exceptions? Do you have when you say in your reply brief, Louisiana case law, quote, clearly stating a cause of action is defined by the operative facts at issue, not by the legal theory asserted, which of the four cases you cite to support that statement is in the context of prescription?
None of those are in the context.
So what's your best case in terms of prescription, Louisiana law?
We didn't find any Louisiana decisions that dealt with that specific issue.
Okay, but that is the issue before us, and that is the issue all the other federal courts have decided, interruption. So they're all wrong, but you don't have a case that says they're wrong.
There's not a case that addresses that specific issue, but our argument is based on different points of Louisiana law. You infer one step from the next. You have, prescription is interrupted against all solidary obligors when a suit is filed against one. That's not in dispute. Filing a lawsuit interrupts prescription as to any lawsuit based on the same cause of action. That's not in dispute.
It's a question of state law. You haven't asked us to certify this question, where you're saying a whole body of federal law is incorrect. You have not asked us to certify it, have you?
No, Your Honor, we haven't.
Go ahead. Judge Stewart said this is your time.
Nor is it in dispute that a cause of action in Louisiana law is defined as the operative facts that give rise to a claim. Logically, we take all three of those things together. That means that a cause of action can be interrupted. The prescription on a federal cause of action can be interrupted by filing a state claim that is based on the same cause of action. And if we're not disputing any one of those points of law, then how can we dispute the last one, other than there are federal district court decisions that have said that? Are there any more questions? If not, I'll turn it over to Ms. Culotta.
Nope.
Thank you.
That's your argument? We're good with it. All right. Let's go on.
Good morning. May it please the court. I'm Renee Culotta, here on behalf of Ernest Leger, the current commissioner of the Louisiana Office of Alcohol and Tobacco Control, who's been sued in his official capacity, and Troy Hebert, the former commissioner of the ATC, who's been sued in his personal capacity. Plaintiffs' arguments don't give credence to some fundamental axiomatic areas of law with regards to subject matter jurisdiction. And the first is that under the 11th Amendment sovereign immunity, the court only has jurisdiction through ex parte Young. The 11th Amendment sovereign immunity deprives the court of subject matter.
Well, we know all that. We know ex parte
Correct.
Young very well. So, but didn't he in his original complaint ask for declaratory relief as well?
Correct, Your Honor, but declaratory relief would not survive this, and the reason is that under the court's rulings, specifically Warmock versus Pecos County and Nelson versus University of Texas at Dallas, it is only the request for reinstatement that would render the termination an ongoing violation of federal law. So without the request for reinstatement, this is a one-time event that happened 11 years ago.
And I think he
not
did
an
tell
ongoing
he
violation.
told the district court all he wants is reinstatement. So focus on that.
So the reinstatement, we launched a factual attack to that. And why were we able to do it? This is the unique case in which we had a fully developed factual record, because we went to a 4-day jury trial on his state law claims, his under the Louisiana Constitution, so that the plaintiff had made admissions under oath that render him unable to return
So
to
in
work.
this record, which did include some of the state court matters, what specifically would you point to where he admitted to the fact that his old position is impossible to give him?
He didn't admit that the old position has been eliminated and abolished. That was Terry Cook's affidavit, that there is no position for him to be reinstated.
But when does he get the chance to traverse that?
He could have traversed very easily his willingness.
Not could have at the threshold stage now. Why does he have to? What's your case that says at this point, just saying he wants to walk into court, he has to take on this affidavit or this declaration? What's your best authority that that's a burden on him?
Sure, there's plenty of authority from the Fifth Circuit dating back from Irwin versus
Just give me your best case.
The best case would be, I would say, either Crane versus Johnson or Superior MRI Services, which says very clearly, and even Cell Sciences, which says very clearly that once we have made a factual attack, it's incumbent upon plaintiff to show by a preponderance of the evidence that there is in fact jurisdiction. He would have had to show by a preponderance of the evidence, some factual evidence that reinstatement was viable, that it was an option, that it's not a fiction. He could have done that simply with his own declaration by saying he's ready, willing, and able to return to Louisiana, that he's capable of being certified.
He got awfully close to that in the deposition. He said, I'm suicidal, I don't have a job, I've been in Texas for 6 years because I want my old job. And a jury found in his favor that he was deprived of that for retaliatory reasons. So sure sounds to me that he's got some facts saying, I'd like to come back.
But the preponderance of the facts is that he's not able to.
Well, once you talk about preponderance, then you lose, because then we can't decide this. This has to be indisputable.
It is indisputable,
Okay, but
but he's not post-certified. He admitted to that at trial.
Okay. Let's go very slowly about what it is, because my memory, correct me if I'm wrong, is he said, well, of course I'm not post-certified because I've been in Texas for more than 5 years, but I'll darn well get myself certified. The coming back to Louisiana and the getting the right certifications, those are within his power. They're not impossibilities. The only thing that I see, but disagree with me if you want, if you can, the only thing that's outside his, I'll come back and I'll take the job I always wanted before I was improperly fired, is that your client is saying, can't even give him that job. It's an impossibility.
Correct.
Is there anything other than that?
He did testify that once he left the position, it reverted to a civilian position. He testified about
But he's
that
a civilian.
at trial.
He's a civilian.
No, he was an agent.
I know he was, but now he's just
He
a
was the-
regular.
I'm sorry, Your Honor.
Why? Okay, so it's a civilian position. Why can't he get it?
Because he's not qualified for the position. He was not qualified for that position.
He's not qualified as a civilian?
Well, he was a badge and gun agent who was chosen for the position because he was an agent. And then,
Now he's lost his gun, he's lost his badge, but he's a civilian. It's just a civilian job. Why can't he apply for it? Why can't
because
he
it's
get it?
already been filled.
So that's the reason it's been filled. What's your best case that says it's an impossibility to have a job that's owed to you, that a court can't order it? So the defendant, or maybe put it this way, what case allows a defendant to abolish or eliminate a position so as to then say to a court, you don't have the power to give it to me?
The position wasn't abolished so that he would not be able to be reinstated. There was no purpose that it would be abolished because of him. It was abolished because the position was decided to go to a business person rather than an agent at the ATC. That there was no need for a gun and badge agent at the ATC to be in charge of certifications,
It
which
just
is a
seems
business.
like your client's shifting. He can't get it because he no longer has the gun because he lost the certification. Oh, but the new position, he can't have it because he is a gun-type guy. He's not a civilian. It just sounds like there's a lot of debate as to whether the court even has the power to give him a position that he deserves, that he was improperly removed from. And I'm asking, what's the authority that the district court doesn't even have the power? What's your best case?
I think the authority is that he didn't come forth with evidence at the factual, in terms of the factual attack with any of these facts. He instead made the deliberate decision, as his counsel did in cell science, not to come forward with any facts that would dispute the facts that were put into the record, that he was not qualified.
You're relying on
able-
the facts from the state case.
Correct.
I'm saying I think I've looked at those facts, and he's saying there, I would like my old job. I'll do whatever I can to get it. So I'm just thinking, I don't really see this as that narrow category of cases where reinstatement is an impossibility. What's your best case that you rely on, that in this mess of facts, him saying, I want to come back, I want to do it, the court couldn't even have ordered it?
I think the best cases are Crane versus Johnson, where the court said, in Mississippi, for instance, might have suffered some financial, with the DACA immigrants, might have suffered some financial implications from that, but they failed to put in evidence of it.
And that's at the jurisdictional stage.
That's at the jurisdictional stage. And same with Superior versus MRI, which was a standing issue. Superior versus MRI might have had an assignment in order to have standing, but it failed to put any evidence of that into the record as in response to the factual attack. Cell science, same holding, and specifically said they failed to put in evidence.
Well, I've pressed you, we pressed him. You've given us 3 cases, which I surely appreciate. I've got to go back and look at all those 3. They sound like they stand for precisely what you said the district court did here. You've got about half your time left. There's a second issue that, frankly, is still also difficult to me, prescription. You want to turn to that, or is
Yes, I do, Your Honor. Before I leave this issue, I will say that although the district court's decision to dismiss is reviewed de novo, the district court's factual findings, in which it based its decision, its legal conclusions, are reviewed for clear error. So this court would have to find that Judge DeGravel was clearly erroneous in reaching the factual decision that it was an impossibility in order to reinstate him. Turning to the prescription issue, as Your Honor has correctly pointed out, every federal court that's looked at this issue has reached the same conclusion, which is that in order to interrupt prescription, by the earlier filed state court case, the plaintiff would have been required to at least plead facts or law to indicate a federal claim. And every stage of the litigation in the state court case, the plaintiff disclaimed a federal claim. In fact, in his petition, he specifically stated he was filing under the Louisiana Constitution, Article 1.
Do any of those federal district court cases, or R. Joseph versus City of New Orleans, any of them even cite any Louisiana case for this?
They don't cite any Louisiana case.
So what?
This is a federal issue.
But you don't
Tolling is a
deny that we
federal
look,
issue.
no, well, we look at Louisiana law for tolling, correct? You don't deny that.
I think we look at Louisiana law for the issue of what is the prescriptive period. I think for tolling, you look to federal law.
1983, whether an action is tolled, we look at federal law.
That's what Judge DeGravel concluded.
What's your best case for that? That's startling to me, but what's your case for that?
Your Honor, may I get Judge DeGravel's ruling on that?
Well, we have his
It's
ruling.
in his ruling, the best case for that. That federal law determines tolling, and that federal law says that tolling begins the day the injury occurred, which of course is the day.
If you're wrong about that, do you lose?
Do I lose?
If
No,
you're wrong that federal
even
law.
if I'm wrong with that, and it's Louisiana law, under the Civil Code Article 3463, also cited by Judge DeGravel, if they even pled, which they didn't, a federal claim, they certainly abandoned that in the state court. Again, we went through a jury trial, and nowhere on the jury verdict form is a claim for a First Amendment violation of free speech. That was never tried or
But you
brought
agree,
up.
looking at the complaint here, it's just a page or two long. It's identical, the exact same operative facts.
It is the same operative
So it's the
facts.
same
and
parties,
different parties.
same fact, no, same parties, right?
No, the state law claim was against the Department of Revenue. Neither Troy Hebert nor the commissioner are named in the state law claim. And so Troy Hebert would have certainly never known, sitting through a state court case, that he would have been on notice that there was a federal claim in the state court case that could be later brought in federal court 8 years later.
Is that dispositive, the different parties under Louvier or not? And think carefully before you answer.
I don't know.
You don't know. Okay, good. Answer. How do you know? Can you distinguish Louvier?
I cannot, not as we sit here, Your Honor.
That's the principal case he relies on. It's the Louisiana Supreme Court case, which does seem to stand for the proposition, contrary to Ford v. Stone in a lot of our cases, authored by Justice Lemon, right? Louvier, that's what he's primarily relying on, to say that Louisiana is a fact-pleading state, and therefore, if you give notice of the operative facts, it doesn't matter what the legal theory is. And so then he brings that, he wins, he gets a large damage reward. First Circuit takes its time, cuts away some of that, all the way up to the Supreme Court. And if we do interrupt, if that interrupts the time, then he just walks into court and says, same cause of action, same operative facts. Why under Louisiana law wouldn't Louvier say, he's timely?
I don't think it would be timely because I don't think it interrupted it, both as to Troy Hebert or to Commissioner Leger, of course, who wasn't even the commissioner at the time. But I would say that it's not the exact same operative facts because in the state court petition, he specifically pleads the Louisiana constitutional provision and does not make the same allegation with regards to any federal claims. He doesn't use free speech.
Right, but you know
He
their
doesn't use
argument.
deprivation
Their
of
argument
rights.
is it doesn't
He
matter
uses
what his
nothing.
legal. It doesn't matter what his legal theories are. That's what they say Louisiana holds.
But he didn't even allege factual allegations that would trigger the federal. So in other words, I don't think that he didn't say anything about free speech or deprivation of his rights by a commissioner. He didn't say that in his state court pleadings. That would put us on notice that he had a federal claim that after a jury trial, after he wins damages, that he's unsatisfied with the damages, that he's going to come now into federal court and reassert that claim against Troy Hebert.
But Hebert was the one who did fire him.
Hebert fired him.
That's the trial that happened that the jury said, yep, it was retaliatory firing. How could those not be the exact facts he's saying support his claim against Hebert now?
Because he didn't use any of the language in the petition that would put us on notice that there was a federal claim to that. For instance, violating the First Amendment or violating the free speech rights. It was expressional rights, which is specifically defined in the Louisiana Constitution alone. So he limited his petition in the state court to only Louisiana claims. By his language, by his chosen language, he limited it to state law claims only.
Does the record say he disclaimed a future federal case?
He did not disclaim it, but unlike Ford versus Stone, he also didn't come in and reserve it and say, we have a future federal court case that we intend to file.
1983's got a lot of exhaustion requirements. Usually the prisoners, or, if they're the ones, they are expected to exhaust internally the administrative system. You wait on the federal case. We want them to wait. See if you get relief.
Why, as a policy determination, why would we want, not for judicial resources and for the parties' resources, why wouldn't we want all the claims brought at the same time? It is concurrent jurisdiction. He could have brought the federal claims in the state court rather than saving them for another bite at the apple only after he's dissatisfied with the jury verdict. It's either prescribed or it's res judicata. But I don't see that he can have it both ways.
The court had res judicata in front of it, didn't wait for that.
Pardon me, Your Honor?
The court had your argument about res judicata, but we don't have any ruling on that because it stopped on prescription.
Correct.
And it's sort of the Louvier case that you're not familiar with is a little problematic if we look at Louisiana law. He put everybody on notice of the same operative facts, support state or federal constitutional violation. He wins. Then years of appellate, suddenly it's pulled out from under him, and he wants the back pay, whatever it is. So that's his argument, it seems like. And I'll just have to look at Louvier more closely.
Thank you.
You done? All right. Back to you, Mr. Schmidt, if you wish to offer a rebuttal. I was just saying, counsel concluded her argument, and I was saying we're back to you if you wish to exercise rebuttal. That's all.
Yes, sir. I apologize. I'm having, for whatever reason, having a little bit of trouble hearing in here.
Okay. Well.
One point, of course, I'd like to make is that the tolling not only is prescription determined by state law, tolling is as well. That's the Jackson versus Johnson case that's cited in our brief. Also, as the issue of why he did not raise the issue of Section 1983 when jury instructions and things like that were being drafted, he had no reason to at that point in time. This is a unique situation. The state appellate court held that the district court did not have the jurisdiction to award an employee, a probationary employee that was terminated for illegal reasons, back pay. And no court had ever found that in the past, and Mr. Kling had no reason to look at alternate avenues to get that back pay at that time. That is all I have to add after hearing Appellee's argument. Are there any more questions that I could answer?
Well, what about the impossibility that, in fact, your client did himself in the state trial say that job's gone?
All I can say to that is it would be very nice to be able to do some depositions of the higher-ups at LDOR to determine.
But you're not therefore disputing that that was a statement of your client at some point in this trial?
No, it was.
All right. Thank you, counsel.
All right. Thank you.
Thank
you,
Your Honor.
That concludes the arguments in the cases we had docketed for this morning. They will be submitted. With that, the panel stands in recess until 9 a.m. in the morning.